Hey guys, welcome back to the show. Sorry for the long delay. We are waiting for Omar, the tilted lawyer, to get out of a court hearing that he's in right now. His court had technical difficulties, and they were supposed to be on Zoom, and now they had to do phone calls, and so it got pushed back a little bit. Oops, I'm hearing myself come back through your speakers. I don't know why, Brad. So until he gets here, I think what we will do is I'm going to get you guys caught up on this story. I know that Omar has actually read this article, so I don't have to worry about him missing this. But we are today going to talk about my family court corruption investigation. Uh-oh. What did I do? I hit the wrong thing. It wasn't supposed to be on locals. It was supposed to be on Rumble. Hold on. Let me add Rumble. Whoops. Hey there, Rumble. Sorry about that. I hit locals instead of Rumble. Okay. Yeah, now Rumble should be up and going. Okay. Anyway. So what I'm going to do is I'm going to pull up my let's see, present, stop screen, present, share screen. I'm going to pull up my family court corruption investigation that I spent 15 months of my life on, that I wrote on PJ Media. Now, as you can see here, this is the complete catalog. It has 29 articles just in St. Louis alone, and then a bunch more related in other states. Look at this. This was 15 months of my life. And when I tell you guys that I have worked on family court corruption stories for a long time, this is just 15 months of work here. 15 months of my life. And what I wanted, I'm always trying to get family court lawyers to pay attention to some of these stories that I've done that I care about a lot. And Omar agreed to talk to me about some of this stuff. And the first case I wanted him to look at was number 14 on the list here. And I'm going to read this to you because this is a case that's very near and dear to my heart. And by the way, this stream is definitely not going to be monetized. We are going to be talking about suicide, and I'm not going to censor myself. I'm not going to censor myself on YouTube because the facts of this case are really horrific. But I feel like using silly words like ARP or graped really it doesn't do a service to Mikaela Haynes, who lived through these things. It does a disservice to victims when we use words that don't actually describe what happened to them. And so if you do want to support this kind of content and you do want to hear the truth, the uncensored, unvarnished truth, please do make sure that you hit that like and you subscribe and you send super chats or Rumble rants or Venmos, Cash Apps, or become a member like Colorado Canadian here. Thanks so much for the membership. I can't use my soundboard right now. The sounds are hurting everyone's ears. Or at least some of them are. Some of them work and some of them don't. We'll figure it out. So we will not be monetizing this stream because of the sensitive content. YouTube won't like it. But, these things do happen. We live in a scary world sometimes, and I think it's important we talk about it. So this is Mikaela Haynes. I met her mother when I was in St. Louis on the ground doing an investigation into the incredible corruption going on in the family court system there, including guardians ad litem, who were basically making money, huge money on the destruction of families and keeping them in court way longer than they needed to be, colluding with doctors who would falsely diagnose one parent with some, false medical or, psychological disorder to take them away from that parent and give them to the parent who paid more money. So let's read this and get you guys caught up on what we're going to be talking about today. What happened to Mikaela Haynes? Missouri guardian ad litem withdraws from case involving teen suicide after press inquiry. Again, this is another one of my press inquiries that are legendary. I've told you guys about my press inquiries. My press inquiries can sometimes result in recusals and resigning. That's why I have the great wall of recusals and resignations. And this is one of them. This is one of the ones I'm most proud of. This is Mikaela Haynes. She was such a sweet girl. This report is part 14 of an investigative series looking into reported corruption in the Missouri judiciary and family courts. Mikaela Haynes was 14 years old when she took her own life after being repeatedly forced to spend time with a convicted child rapist, her father, Charles Haynes. Haynes is currently in prison. Actually, he got out. He's out now. He is out of prison, in Missouri. He was serving a sentence for raping Mikaela's half-sister Melissa when she was a young teen. The nightmare for this family began when Melissa gave her mother a note. Melissa is Mikaela's half-sister, disclosing that her stepfather, Cynthia Randolph's husband, Charles Haynes, had been abusing her for years. Randolph left with her 3 children, reported the abuse to the police, and filed for divorce. Haynes was arrested, charged, and pleaded guilty to sodomizing Melissa. And you can see here, this is his Farmington Correctional Center information. He was a sentence summary, 7 years, statutory sodomy in the 2nd degree. And he admitted to doing it. He's not only pled guilty, but he admitted to doing it. Guardian ad litem, Jennifer Williams, was appointed to the case because of the abuse allegations. Instead of protecting the children from Charles Haynes, an admitted child rapist, Williams acted tirelessly to give him and his enabler mother access to the children, while accusing Randolph of educational neglect for homeschooling the girls. Even after putting the children into a public school, where both children made the honor roll, proving there had been no educational neglect, Randolph lost custody of the girls to Haynes's mother, Bernice, because of Williams' influence over the court. Randolph reported that Mikaela became despondent after finding out that Williams, who was entrusted to act in Mikaela's best interest in the custody dispute, announced her intention to testify on behalf of Charles Haynes at his sentencing hearing after he pled guilty to sodomizing Mikaela's sister. On 11/23/28, she heard that Jennifer Williams, her own guardian ad litem, was going to be a character witness on behalf of Charles Haynes for the sexual molestation of Melissa that devastated Mikaela. Cynthia Randolph told PJ Media, and Cynthia Randolph is her mother, by the way. She said, "I'm going to hang myself before I go back to foster care." Mikaela hung herself in the family home the very next day. Actually, it was outside. I got that wrong. She hung herself on the property outside the very next day. So sad. PJ Media obtained the court transcripts of that sentencing hearing, at which Williams did indeed testify, even after her minor client killed herself, downplaying the danger that Charles Haynes posed to teen girls. "I do, however, have concerns that the father and his family have not seemed to be able to have any access to the children for quite some time," she said at Haynes' sentencing hearing for sodomy of a minor. And here's the transcripts. I have the court transcripts. Let me show them to you. Here it is of her saying that. And the question that comes after is, "And that's partly because of the criminal case. Is that true?" And she says, "It's my understanding that's a large part of it." I don't know. Is it possible that maybe he can't access the children because he raped one of them? I don't know. Seems reasonable to me. Here's a question in the transcript. "Do you have any concerns based on your investigation in this case as it relates to Sarah and Chuck going forward?" Sarah's Mikaela's younger sister, "of the same type of thing repeating itself?" And her response was, "I honestly can't rule anything out at this point. Well, I don't know that I think anything would happen. I can't say that anything wouldn't. And that's unfortunately my role as a guardian ad litem, is I have to protect that child." Unfortunately? It's unfortunate that you have to protect a child from a child rapist? "In your presence, the defendant has not acted inappropriately with Sarah." And the answer was, "Not that I'm aware of. I've never seen anything inappropriate." And then she said, I have had one meeting where father brought them to my office, and I was able to see him interact with both of the minor children at that time, and I didn't see anything inappropriate during that." Yeah, like a child predator is going to prey on the children in someone's office in front of a court professional. Clearly these things happen behind closed doors. What an idiot. Before Mikaela's death, Williams showed a bizarre affection for Charles Haynes and his mother during her time as the gal, and continually insisted that his daughters must have a relationship with the convicted rapist and his enablers. On Williams's recommendation, the girls were put into the sole custody of their 90-year-old paternal grandmother, Bernice Haynes, who had a known history of not supervising her rapist son when he was in the presence of girls, after Williams alleged they suffered from educational neglect in Randolph's care. Not only did she not supervise her son with them, but Mikaela reported to several doctors that her grandmother was drugging her with massive doses of Benadryl to help her sleep. And coming to the program now is Omar, the Tilted Lawyer. How are you, Omar? Omar Serrato.
Good morning, Megan. I gotta compose myself.
Well, you're good. You're good. Thank you so much for being able to join. I'm sorry that we had the delays and everything. Sorry you had a rushed morning. I know how that can be.
Well, it wasn't supposed to be a rush morning, but as Mondays go,
Yeah, it happens.
the of it all.
I was just full tie Omar. This is different. This is full
it's
tie.
about to come off. It's usually my habit. As soon as the hearing's over, the hell with this. Boom.
There you go. So I'm catching the chat up on the article that I sent you. I think you read this already, right?
I did.
Okay. All right. So I'm catching the chat up because they haven't got there quite yet. So we're right about here. She had a known history of not supervising her rapist son when he was in the presence of the girls. Not only did she not supervise them, but Mikaela reported to several doctors that her grandmother was drugging her with massive doses of Benadryl to help her sleep. This began the nightmare that ended with Mikaela's death by hanging. Butler County, Missouri Judge John Schock acknowledged that Bernice Haynes did not properly supervise the convicted child rapist, but gave the children to Haynes anyway, despite multiple therapists and Children's Division's reports saying that Bernice Haynes' house was not safe for the girls and they should be returned to their mother. The issue before the court is the temporary custody of the party's two minor children. Bernice Haynes testified that she is willing and able to care for the minor children. After all other evidence was presented, the guardian ad litem testified that even though she has concerns about Bernice Haynes' failure to fully supervise father's visits in the past, her recommendation is that the minor children be placed with Bernice Haynes. The gal stated that the placement of the children with their grandmother is in their best interest at the time. The court finds, on a temporary basis, the minor children's best interests are served by residing with the intervener, that would be grandmother, and all decisions concerning the children's schooling should be made by her. Judge Schock wrote on December 15, 2016, that after all other evidence was presented, the guardian ad litem testified that even though she has concerns about Bernice Haynes' failure to fully supervise father's visits in the past, her recommendation is that they be placed with Bernice Haynes. Williams recommended the removal of the girls from their mother's custody because she had concerns about educational neglect, influence, and manipulation, but admitted that none of her concerns were hotlineable, meaning that nothing she was concerned about was a legitimate or lawful reason to take children from the care of their mother. She also accused the rape victim, Melissa, of manipulation in a shocking display of victim blaming. Williams wrote in an email, "None of the allegations were hotlineable, but were concerning nonetheless. They ranged from flat-out manipulation by mother and Melissa, emotional abuse by mother and Melissa, not having enough food in the home, and being severely punished for making disclosures about things that had gone on in the home in the past." Randolph denies all of those allegations and pointed out that if any of those things had occurred, Williams could have made a hotline call to report the alleged abuse, prompting a social services investigation. She never did. Severe punishment is child abuse. Why didn't Williams report that alleged punishment if she believed it happened? As a mandated reporter, she is required by law to report abuse, but admitted in her own email that nothing she was concerned about was hotlineable. PJ Media is in possession of multiple Missouri Department of Social Services reports that affirm that Randolph's home was safe. There are no concerns with Randolph or in her home, and there hasn't been proof of any since the beginning of the case, wrote Social Services in a letter to Judge Schock. This was one of the cases, by the way, that CPS was actually on the side of the right parent that I've ever covered, and they were begging the court to put the children with mom. It was sick, and no one was paying attention. After Mikaela was put into custody of the 90-year-old who gave Chuck Haynes full and unfettered access to his teen daughter, Mikaela's mental state deteriorated to such a degree that she was cutting herself and was admitted into a mental hospital where she was drugged with a medication, Remeron, that has a listed side effect of suicide. When her mother objected to the use of that drug, the doctors turned on her and reported that she was uncooperative and banned her from the hospital. "I went there every day that I could," said Randolph. "They wanted to give her a medication to help her sleep and wanted me to sign it. Randolph refused after seeing the scary side effect. They would never let me back into the hospital to see her after that." Mikaela was put into foster care after her 9-day stay at the hospital. The doctor would not allow Mikaela to go back to Bernice Haynes because he believed she was suffering abuse there. But for some reason, he also decided she couldn't go back home with her mother, despite the absence of any evidence of abuse in her home and repeated requests by Mikaela to go back to her mother. In 2017, the state returned the girls to Randolph's home. The children's therapist reported that the girls were doing very well back at home. Their grades were good, their mental state was improved, and they were thriving and happy. On December 15th, 2017, Dr. Jerry Marks wrote, "Mikaela has achieved an honorable mention on the honor roll this past term, and Sarah is on the honor roll this term. Both girls talk about feeling happy to be back with their mother and are having a hard time understanding the reason they were placed in foster care in the first place." Despite how well they were doing, Williams continued to try and reunify them with child rapist Charles Haynes. He was on trial for raping Melissa at the time. Dr. Marks accused Williams of witness tampering and professional misconduct. Marks wrote on March 20th, 2018, "I have to be on the record saying that I think what has happened in the last 2 months with Mikaela and the guardian ad litem is a form of witness tampering after Williams was continually showing up at Mikaela's school with gifts from her father and grandmother. Marks had repeatedly warned Williams and the court that any contact, including gift giving, should not be allowed under any circumstances. As a result of this continued pressure from the Haynes duo, facilitated by Williams, Randolph reported that Mikaela became very ill with stress disorders. Marks submitted affidavit after affidavit, begging the court to stop allowing the Haynes family access to the girls. No one listened. Marks also wrote that he believed Charles Haynes had molested Mikaela. "I believe that Mikaela is also a victim of her father, but she is unwilling to disclose to me because of what she has been through, and she has watched what her sister has been through with the court process. If she does disclose to me that she has been sexually abused, I am a mandated reporter and will be required to call the Division of Social Services. This will trigger further issues with the case," Marks wrote. Mikaela did disclose sexual abuse to her foster mother, but knew not to speak to a mandated reporter because, in her experience, reporting abuse to the experts only gets the abused child into more pain and suffering. After Mikaela's suicide, Dr. Marks submitted another letter to the Attorney General of Missouri trying to get law enforcement to do something about Williams and her repeated violations in this case. The letter said, "It is my understanding that the gal who was appointed to the cases of both Sarah and Mikaela testified at trial on behalf of Mr. Haynes. This testimony, if it occurred, is in my opinion more than just a conflict of interest and may rise to the level of professional misconduct and may have been the cause of Mikaela's death by suicide." The Attorney General did nothing. There has been no official investigation into the conduct of guardian ad litem Jennifer Williams, the judge, or the other attorneys involved in the case who facilitated a child rapist's repeated access to the children. Mikaela Haynes loved sign language and was studying diligently to become fluent. For part of Mikaela's homeschool curriculum, Mikaela studied and loved American Sign Language. She spent hours watching YouTube videos and practicing it. "There was a deaf elderly couple that she went a few times to see and practice it live," said her mother. Mikaela also loved her sisters and cooking. In her suicide note, she wrote, "None of this was or is your fault. I want you to keep being you. Don't let this affect you in any negative way. I love you with my whole heart. I can't keep doing this anymore. Thank you, Mom, for making my life on this flat earth as easy as possible and always doing the best for me. You don't know how sorry I am." PJ Media attempted to contact Jennifer Williams to ask her why she made the decision she did in this case. She did not respond. She did, however, withdraw from the case on April 27th, citing the press inquiry and the public attention as the reason. Williams currently works for the University of Missouri Extension as a county engagement specialist in community economic development. Whew. All right, Omar.
Where do you even start with all of that?
I know. Where do you even start? What was your reaction after reading that article?
I think my first reaction last night when I was reading it was I emailed you basically WTF.
Yeah.
With this case. It flies in the face of everything that I know about family law, about how we protect children or we're supposed to protect children. You have everything about that case is wrong. I mean, let's start with the person supervising the convicted rape essayist. I don't even know what
It's
the
all
word.
right. We're demonetized. Say it.
Okay,
Just he's
if
a
a
child
convicted
rapist.
rapist is 90 years old and his mom, even if she wanted to supervise him, what is she gonna do?
Right. 90 years old.
And
She was barely mobile.
it's been my experience that whenever you have somebody convicted of a crime like that, that's so close to the child, a sibling, it's not a question of what kind of visitation time they're going to get. It's going to be supervised and by a professional monitor that's not 90 years old living in the same house. There's no overnights. There's no 1 to 6 p.m. It's usually like 2 to 4 hours for a month once, if that, and it's carefully monitored. I don't understand the reasoning. None of it makes sense. It was educational neglect that was cured by the fact that you then put her in a public school and she performs well enough to be on an honor roll.
And even social services was like, we don't know why this happened. There's nothing here. Her house is safe.
The
Her
fact that
mother's a
she's
good mother.
testifying at his sentencing hearing as a character witness was just absolutely bizarre.
Mm-hmm.
And her carrying on about trying to, well, the mother is manipulating the children, obviously. And as a result, I don't know what's going on. I'll tell you what, I have a lot of cases that are dealing with not these specific allegations, but similar allegations.
Mm-hmm.
And I've literally heard judges say, when presented with the fact that children say certain things, say, yeah, well, children say a lot of things, which is true. And it kind of goes back to a lot of what we were talking about on Friday with the other case about the danger of people making false allegations, because these judges, you brought up two possibilities. Well, you brought up one, but there's another one that I see. And the one that you had mentioned is that, oh, well, they see these CPS workers all the time and they develop relationships with them. They become very persuasive with the judge, and the judge basically takes their lead and they do whatever. The other aspect of that is the judges hear so many of these allegations that at some point they start to lose volume, and they see so many of these children legitimately manipulated into saying things. But I feel like that's easy enough to ferret out. Like there's a way, like I've had to cross-examine children that have made these allegations before, and it's not at all like what you would imagine. I mean, I'm sure. I don't know if you've seen them or if they would allow it to be seen, but usually when we cross-examine children, there's special accommodations made. Very rarely is it, hey, the judge is right here, child is on the witness stand with both of their parents staring right at them, hoping that they're going to say the right thing. I've seen that happen once out of hundreds of times. Most of the time, it's you take the child in chambers, you give the judge a list of questions to ask the child. This is what I think is important that you need to ask and get her reaction from, or his reaction of. And then the judge asks the questions, and the attorneys get to hear either over the loudspeaker or like on the phone or something, and they'll take testimony that way. But you could kind of tell right away when a child has been coached to say certain things. There's a completely different reaction. I caught a glimpse of the introduction that you did. And, you know, when you read this case, it's one thing. When you hear that audio, I don't know if that was of Mikaela or of her sister basically pleading with mom, I don't want to go.
Oh, I'm going to play that. I'm going to play
Oh.
that. So that was actually, I didn't actually play it. I was going to make it the intro of today's show, but we had with the problems. I thought I'd wait till you got here because I wanted you to see it. So I have a little video to play, and this was basically a recap of some of the St. Louis problems, right? What was going on in St. Louis at the time. Now, this is not a recording of Mikaela, although there are lots of those too. I have those, and I've played them on this stream a couple of times of her, you know, begging people to listen to her and to stop this. What I made was a highlight reel of the other children in St. Louis, many other children begging for help. So the one in the beginning, these are multiple victims of these guardians ad litem who refused to listen to the children. So you're going to hear Elaine Pudlowski confronting a mother saying, I know that this is what she said happened, but I wasn't there. You weren't there. He says it didn't happen. She says it did. That was a different child. And then the next segment you'll hear is another child, someone else's 14 or 15-year-old, begging Judge Zellweger not to send her to her father, who she claims had molested her. And in that was the one recording that I got contacted by the Missouri court trying to tell me I broke the law by putting that online. And I'm like, no, screw you, man. I'm in New York. You're in Missouri. Go ahead and try. I'm not going to, I refuse. And you'll see in this clip me laughing about disobeying judges. And now I respect judges when they do good things, right? But I have no respect nor care for any judge who is holding secret meetings. And that's the one that I'm referring to in this one, a secret court hearing where he kept the press out, the press on the ground. He kept the public and the press out of the courtroom and had a secret hearing in a criminal case against a mother that they claimed had threatened Judge Nicole Zellweger. There were like 20 different families who were going through this in St. Louis that I was covering, maybe more. I have binders full of families. And in this one case, the one where the 14-year-old was begging her not to send her with her father, her mother sent an email to the judge saying, you're going to be held accountable for your actions. And they used that. And she even said in the email, accountable because of the standards of judges. There are standards judges have to live up to, and I'm going to hold you accountable to those. And they used that to say she made a violent terroristic threat towards the judge, arrested her, threw her in jail for 2 weeks while she had no counsel, no access to counsel, no hearing. And when they did hold a hearing, they held a secret hearing where they kicked the public and the press out of the room. And so I got a recording of it and I put it on the internet because that's some kind of bullshit, right? Like you can't do that in a criminal proceeding. It was an arraignment, for God's sake.
Yeah, not in a criminal for sure.
Yeah, criminal proceeding. So anyway, so that's in there. And basically a bunch of headlines of these different families. I actually made this, I think, before I even met Mikaela Haynes' mother. So this is what was going on in St. Louis, in Missouri at the time. So I'm going to put this up on, and we're going to play this for you guys. Just as an FYI, when the music kicks in, it can get loud. So you can man your volume. I have it turned halfway down here. Here we go.
I believe that something happened to her. I don't believe your daughter would just make something up. Okay? Did he stick his finger up her butt? I don't know. I do not know. I will not guess. She says he did. He says he didn't. You weren't there. She wasn't there. I wasn't there.
I understand. No, you don't understand. You understand you don't want to go with a child molester. Children are still children. You're still children. You're still a child. You're not 18. You don't get to make these decisions.
I don't want to be here. I hate it so much. I don't want to be here.
Baby, Mom's doing everything that she can. I promise you. I know you're sitting there and you don't know what's going on, but I promise you, Mom is doing everything that she can. Okay? Okay, baby. Okay.
We're about to disobey a judge. I don't know, Mike. What do you think? Do you think we should take the risk?
No, it's one of my favorite things to do. Please play the clip.
Is no authorization given by the court for any type of electronic recording made of these proceedings.
Whoa.
So in the event that there is anybody that is making a recording of any form or of any type, that must cease immediately. In the event that there is a recording that is being made and the court is able to determine who it is, you may be subject to contempt of court proceedings. So,
I'm sorry, sir, but I don't think that that's legal.
Since that moment, Judge Nicole's lawyer, including contacting your employer, has attempted to remove that audio, it's audio video, from the internet.
Is this the
Judge
judge?
Zellweger, she comes with the horns, I think, the devil horns.
You have all the guardian ad litems in cahoots with the family practice attorneys, and this is so deep and corrupt that I just don't know what can be done to fix it. I just really don't.
We're doing it right now.
This threatens to take down the entire system. The judges are in on it.
There's 38 of us on the call. Once they take you down, then we're all next.
We can call ourselves Cash for Kids. Yeah, LLC. I don't have any other kind of business.
So the clients that I get on my GAO cases don't have money. So my clients complain all the time, but most of them don't have money.
Yeah, wow. So that was what started it all, was that leaked Zoom call. I don't think I told you about this, Omar. So what began my investigation into St. Louis Family Court was a leaked Zoom call with 38 or 40 guardians ad litem on a Zoom call, and somebody on that call, and we still don't, to this day, don't know who the source was. Somebody leaked it to the media. And we put it up on YouTube, and the entire call, and I'm going to send it to you so you can watch it sometime, because your jaw will be on the floor. They're in there discussing their cases with each other. They're discussing how they get out of the complaints that are being made about them. They're discussing how judges, the chief judge, Judge Burton, is on their side and helping them get away with this stuff. They're discussing how they are fighting against the parents who are going to the press against them. That one leaked Zoom call led to the entire St. Louis 21st Circuit Court having to recuse themselves from a lawsuit by one of these parents against. So Evita Tolu, who happens to be the attorney for Mikaela Haynes' mother, was also in court. She's the one who brought the lawsuit because of her divorce in custody case, what they did to her. And it was her lawsuit they all had to recuse themselves from because of that leaked Zoom call where they're basically plotting against her, so trying to figure out who's the leak, who's sending stuff to the media. It's got to be somebody in the court system. They're hiring a private investigator to find them and to dox them. It's incredible. So that's what tipped me off that something very bad was going on in St. Louis. That's why, and I did all of these articles that I have here on my complete catalog that I sent you. These were all the articles I did before I even found Mikaela Haynes, who was number 14.
Yeah.
We had, the first one was the first girl who was sent to live with her allegedly abusive dad while they jailed her mother. The second one was all of them recusing themselves after that leaked court guardians and psychologists, the leaked tape. It's incredible. And there were others. So we had judges colluding. We had an email from the chief judge saying that he was going to help the guardians who were being sued by Evita Tolu. He had to resign in disgrace because of that. So Chief Burton is gone now. He's not even a judge anymore.
Rightfully so.
What was that?
Rightfully so. It wouldn't surprise me if it was somebody inside that courthouse leaking all of this stuff.
Yeah, we still don't know.
Yeah.
Still don't know who it was. But there's another case in here, a murdered child. The judge sent the child to live with his abuser father, and his mother had begged and pleaded for them not to do it. And the kid goes missing for 18 years. 18 years the kid is missing, and mom's been saying for 18 years that he did it. And you know when they discovered that he did it? 18 years later, he molested some strangers' kids. And that's when they decided to bring charges against him for murdering his own son. I mean, these scandals in this court, it's horrible. I mean, it just keeps going on and on and on. I have 29 articles about St. Louis and the court corruption, including so many different families. It took me 15 months to do. I went on a trip to St. Louis, and I went to the Capitol with these families to speak to lawmakers about, making new standards for guardians ad litem, about going after judges who were colluding with these people and going after psychologists. No one would listen. It was really upsetting. So getting back to the Mikaela Haynes case and what's gone on in that, at some point, her mother filed a lawsuit against Jennifer Williams. It's a wrongful death lawsuit, and that's been making its way through court. So back on November 22nd of 2021, I reported that Jennifer Williams, that's this woman here, was served in a wrongful death suit. She tried to claim immunity because a lot of these people got immunity in the different lawsuits that happened. I think there were 4 or 5 lawsuits by different families, and they all got immunity.
Has it ever came out that she had some kind of weird relationship with this guy? Like, what
No,
was
not yet.
so much advocating for him?
God, I wish I knew, but it is a really small town in Missouri. It's like the smallest of small towns. And like everyone's connected to one another. And there's just like a whole lot of political gamesmanship going on over there. And I think that it's because Charles Haynes's mother has a lot of money in that town. And it is like she's connected to a lot of powerful lawyers and stuff in that town. Of course, I say powerful lawyer, we're talking about a very tiny little town in Missouri.
Yeah.
How powerful are they? But the smaller the town, the more power you have, right?
Well, that's a very real thing. I've been my first exposure to that. I mean, I told you about my story at the DA's office, but my first case ever having to deal with CPS. You're practicing in LA County, this huge metropolitan area. You would think that you wouldn't get the small town treatment, but in these small circles, in these very niche style courtrooms, dealing with dependency and dealing with placement of children, it's a very small circle of lawyers and CPS workers and guardian ad litems and people that all work together. When you walk into there, it feels like you're an outsider. 100%. Like, you don't get to have your hearing called until you speak with CPS, put you on a list, and then they tell you when you're going to go. They kind of call all the shots. I was literally sitting in a courtroom listening to CPS workers adverse to my case, essentially having ex-parte communications with the judge by themselves while I was outside. I mean, because they sit there.
They do that.
And it's bizarre, and they're not nearly as crazy as these cases that you're describing, but I have all of my attorney friends have all stated about these specific types of cases that it really feels like you're in kangaroo court sometimes when you're in there. Like, the rules of evidence don't apply. We don't know what the legal arguments they're looking for. We think that the standard is best interest of the child. That's what the code says. That's what the Welfare and Institution Code says. That's what the Family Code says. But in practice, they shift the goal line so much. Just the example of, okay, well, we don't think it's in the child's best interest because she's been homeschooled and we feel like educational neglect is happening. And so they make a ruling, fine, we're going to put her in public school. And then she does better. And on the other hand, you have this convicted rapist that they're advocating for, that, well, we think it's in the best interest that the child stays with her under mom's supervision, who's 90 years old. And we're going to limit contact with mom because of, whatever reasons. It just blows my mind. Okay, when I was reading that article, I was getting confused. So at what point was he convicted then of raping Melissa?
So that all happened right before she committed suicide. It was actually happening at the time. She committed suicide the day before she was supposed to go to court, and Williams was going to testify on behalf of her father, and Williams still did it.
So pending trial, he's literally standing trial for sexually assaulting her younger sister.
It was an older stepsister.
And they're placing her in his care. Trying
to get her
and
visitation.
Taking her away from mom.
Mm-hmm.
But like she even says, well, there's not really a good reason to do this. But I feel, everything's I think, which is not the standard. I got to say, I got to stick up for the judges in my area, because I have never seen a ruling like that where there is active sexual assault charges. Usually when that happens, in my case, it's automatic. Okay, well, no visitation until we figure this out.
It's the law, Omar. In Missouri, it is literally the law that if you are convicted of child molestation, you cannot have visitation. You're not allowed to have it. And these judges ignored the law. Evita, who was Evita Tolu, she's the attorney. She was going to be here with us today, but she got called into court. Evita was actually, I've seen the transcripts of this. She'd be in front of the judge quoting the law to them, and they would just ignore it and say, well, we have to have a custody hearing. We still have to have a custody hearing. She's like, no, you don't. The law says he can't have custody. We should not be having a custody hearing about Sarah, the remaining alive child, because he cannot have it. It's the law prohibits it, and they do not care.
I mean, you could have a hearing based on why the law doesn't apply, but you don't give somebody temporary custody pending a hearing, knowing that they're standing trial for something that is literally going to make it legally or illegal for them to have custody.
Yeah. Charles Haynes' attorneys were well-known men's rights attorneys in that area. And they have a reputation for just, bankrupting the other party. And I think that's what it was about. They would file these motions about, having a custody hearing for this man when he gets out of prison. It's like, what? That's just to keep her coming back to court and draining her bank account, because he can't have that. The law says he can't have it. And the fact that the judges allowed it to go forward is just incredible to me. Incredible. Sarah Farnsworth, what are you talking about? By the way, we're not talking about Rekieta right now. So if you would stay on topic, I would appreciate it. I'm not surprised Megan Fox is censoring anyone who reminds her of the claims she made about the legal issues with Rekieta's case. I didn't make any claims about that, and we're not talking about that right now. This is your warning. If you want to keep it up, you can get banned off my channel. That's fine. You don't have to come back here. I didn't make any legal claims, and we're not talking about that right now. All right. Mods, if she keeps it up, just ban her permanently. Thank you. We're staying on topic today. So a wrongful death suit was filed against Jennifer Williams. She's the only guardian ad litem that she lost her bid for immunity. We have a new document in this case that just happened. And it is like, I don't know, it's 17 pages or whatever. I don't know if we'll get through the whole thing. But I did want to read through it because I haven't read it yet. And I thought maybe you would have something, let's see, you might have something to say about it.
Certainly. So they filed this in 21, right? Or they filed the wrongful death in 21?
Yes.
Is this a new complaint?
It is. This is not a new complaint. This is it's a plaintiff's motion for sanctions and attorney's fees and memorandum of law. So what happened here is it made it through the immunity claim, which none of the others did. So that was kind of exciting. And then since then, I haven't really seen anything happening in the case. Yeah. But this was just filed on May 31st. So we're going to read through this and see if we see anything interesting. This is on behalf of Mikaela, filed by her mother, Cynthia Randolph. So plaintiff Cynthia Randolph urges the court to impose sanctions and seeks payment of her attorney's fees against Jennifer Williams Law, Spain Miller and their counsel, Susan Diamond, Dustin Gold, blah, 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 all these people. The defendant's actions in concealing that Williams was not certified under Missouri law as a guardian ad litem during her involvement in the divorce and juvenile cases, defendant's repeated omissions and misrepresentations to this court, the Ripley County Circuit Court, divorce and juvenile, and plaintiff were in bad faith to multiply these proceedings which prejudiced plaintiff. Defendants abused the discovery process, engaged in unethical self-help discovery, and tampered with witnesses by posing as law enforcement and lawyers for defendant Charles Haynes. Defendants Williams, Spain, Lee, and Miller are all attorneys who have approved the conduct subject to this motion. In this wrongful death suit, plaintiff sued Williams and Spain Miller, seeking accountability for driving plaintiff's daughter, Mikaela Haynes, to suicide. The Ripley County Circuit Court appointed Williams to serve as a gal on May 6, 2016, and reappointed her again on January 30th, 2017, per the Missouri Supreme Court Guardian Ad Litem Standard 14, which states in part, The court shall not appoint a lawyer to serve as GAL until the lawyer has completed 8 hours of continuing legal education devoted to guardian ad litem training. Thereafter, to continue to be appointed as GAL, a lawyer shall complete 3 hours of continuing legal education devoted to guardian ad litem training annually. The program sponsor shall obtain approval of the program for continuing legal education from the Missouri Bar. Any continuing legal education required by this standard shall not be completed by self-study. In addition, the program sponsor shall obtain approval of the program as guardian ad litem training from the presiding judge in the circuit where the training is offered. Completion of the training hours shall be documented by an affidavit or other evidence filed with the appointing court by July 31st of each year. Williams did not complete mandatory GAL training at the time of her appointment, but she concealed it from the divorce court. Williams received her GAL training for the 2015 CLE year on May 26, 2016, 20 days after the divorce court appointed her. Williams did not complete any GAL training for reporting CLE years 2016 to 2021. Williams never completed any GAL training accredited by the Missouri Bar, as plaintiff confirmed with the Missouri Bar CLE and accreditation compliance specialist, Ms. Sheila Duncan, on a recorded phone call on February 26, 2024, with the audio available to the court. Williams never filed any GAL completion training affidavits with the Divorce and Juvenile Court required by GAL Standard 14. Williams never informed the Divorce and Juvenile Courts that she had no GAL training. Except for the May 26, 2016 certificate, Williams produced no evidence of the approved GAL training for the years she posed as a GAL in the Haynes divorce and juvenile cases. I mean, holy crap.
She's going to, okay, my initial thought, if all of that is true, it's easily verifiable. They're talking about bad faith conduct going back to 2015. That's she's effed once this gets to court. It takes away the fact that it's for sanction, it takes away her bag that, hey, we're going to try to drain the bank accounts of our opponents. Not if they sanction and make her liable for all the fees and really the county for the fees, a plaintiff. But how much of that is, I gotta assume if it's licensing stuff, that's easily verifiable and not really, she's not going to have a good excuse for that.
I think, and I would have to verify with Evita, but I think that that's why she lost her bid for immunity, because they verified that she wasn't actually licensed at the time.
Exactly.
Yeah. Yeah. Which was a real big bombshell. But here's the thing about the St. Louis family court corruption stuff. The guardians ad litem actually on that leaked phone call, the Zoom call, they actually talk about trying to defeat the guardian ad litem standard laws that they were trying to put into that the legislature was trying to put into position for years. They would lobby against that. So they actively wanted to not have standards for guardians ad litem in their county. And they would spend money and time lobbying against any laws to hold them accountable. And so they were ignoring the standards. They didn't want standards. They didn't want accountability. Just ignoring them.
Anyway, apparently.
Right.
Because if it wasn't for this, like who's to say there's not what's the percentage of guardian ad litems in that county that are actually licensed?
Oh, I don't know. That's a good question.
And this is the one that's coming to light because of this wrongful death action. But it doesn't matter. If they're actively lobbying for the licensing stuff and not enforcing it, it's kind of just asking for legislation to uphold the status quo, which is we're not enforcing the licensing anyway.
Oh my goodness. Cages, thanks for the 5, says, this is terrifying to learn about. I live in Ripley County, Missouri, and haven't heard anything about this. Yeah, it's a horrific story. It's a really bad story. And by the way, one of the worst things to happen in Ripley County was one of the hearings that was being held on this. I got a congresswoman, like someone from the legislature in Missouri, I got her to attend a hearing. She drove all the way to Ripley County to attend this hearing, and they blocked her access from the courtroom. They would not allow her in.
How?
An elected representative. They claimed confidentiality for the children.
I was going to say, was it because of a minor, a hearing regarding a minor?
But it wasn't regarding a minor. It was just this divorce case nonsense. It was her divorce case, and they blocked this representative from going in the courtroom. And she called me on the phone saying, I can't believe it, but the judge wouldn't let me in. They said I'm not allowed in. And I begged her, please start impeachment proceedings against this judge. You have the power to do that. And it's like they all just forgot about it. And they went back to their, to the Capitol and just decided, oh, well, the judge won't let us in his courtroom. So I guess that's all we can't do anything about it. Total garbage.
Like, what was the specific hearing for in that family law case, on the divorce case?
I would have to double check with Evita, but it was not about children, and also, I mean, the children weren't in the courtroom.
Well, if it was usually the way they do it, I mean, here in California,
it wasn't a juvenile court hearing; it was a divorce case.
Yeah, so divorce cases are usually open unless it's about like domestic violence or something.
Right.
If it's not specifically about that, it's the courts are open to the public. It's just.
But the legislature, by the way, has authority to check the judiciary. And if in her position as an elected official, she wants into a courtroom, she legally has a right to be there, whether or not it's a juvenile court. That's the thing that killed me about this. In her legal capacity, she has every right to be there. And that they kept her out, it's just they're holding secret courts all over Missouri. All over it. It's terrible. Yep, star chambers everywhere. Defendants did not produce any GAL Standard 14 records showing Williams was a Missouri certified GAL. From 2022 until March 2024, defendants gaslighted plaintiff that they had produced Williams' GAL certificates to plaintiff, mocking plaintiff for not reading her emails and paying attention to the case. On March 14th, 2024, at the deposition of Miss Cassie Rideout, Mikaela Haynes' foster mom, plaintiff asked defendants again for Williams' GAL certificates while recording them. At first, counsel Collins and Diamond gaslighted plaintiff. Realizing plaintiff was recording them, Diamond said, Williams was not required to keep any GAL records, Collins screamed. We are not obligated to provide you anything. On March 20th, 2024, 2.5 years into litigation based on defendants' misrepresentations to the court that Williams was a GAL, plaintiff confirmed that Williams was never certified as a GAL and was not authorized to practice as a GAL under Missouri law after causing exorbitant waste of the court's time and the plaintiff's resources in this litigation. Document 237, page 4. Defendants filed 2 motions to dismiss in the documents listed below. In the first motion, defendants argued that Williams, as a GAL, was immune from liability for her conduct within the scope of her GAL duties. Plaintiff spent significant time and incurring legal fees briefing the defendant's first motion.
The whole way that she's not even a legitimate GAL.
Right. And I think that's why she lost her immunity. The court spent significant resources addressing the defendant's first motion to dismiss. Based on Williams' fraud that she was a GAL, the court dismissed plaintiff's counts 2 through 4, finding that Williams was immune from liability for the actions within the scope of her GAL duties. In their answers, defendants misrepresented to the court and plaintiff that Williams was a GAL. Plaintiff incurred legal fees and wasted time on addressing defendants' answers premised on their misrepresentation that Williams was a GAL. In the second motion to dismiss, defendants argued that as a GAL, Williams only owed duty to the divorce and juvenile courts as their agent and owed no duty to Mikaela Haynes.
Get the fuck out of here.
Oh, yeah, I read it. That one I read. Their motion to dismiss said she had no duty to the child.
Wow. Was that really her argument? She has no duty to the child for whom he's responsible for their best interests?
Yes. That was her argument, that her duty was to the divorce and juvenile courts and not to the child.
I guess that would be true if she's not a legitimate GAL.
Yeah, I guess. That's true. Defendants claimed the plaintiff did not allege sufficient facts that Mikaela Haynes suffered from severe emotional distress and depression. Mikaela Haynes was hospitalized twice for suicidal ideations and was diagnosed with severe depression while Williams was on the case. Mikaela Haynes' pediatrician documented that Mikaela Haynes was sexually abused. Mikaela Haynes committed suicide after Williams repeatedly threatened Mikaela Haynes to put her in foster care or with her sexual abuser. Haynes, if Mikaela disclosed to anyone that Haynes sexually abused her. Williams threatened that if Mikaela or Melissa, Mikaela's older sister and plaintiff, testify against Haynes, Williams would return Mikaela and Sarah, her younger sister, to foster care or Haynes who would not be incarcerated for sodomizing Melissa, but would be placed on probation. On November 24th, Mikaela took her life after she learned that Williams would seek Haynes' probation at his sentencing hearing on November 26, 2018. In her final note, Mikaela stated she could no longer deal with the court. Haynes admitted to sexual abuse of Melissa on May 29, 2014, in a recorded conversation with plaintiff, and pleaded guilty on September 4, 2018, to the deviant child sodomy of Melissa. On December 12, 2018, as Mikaela's body lay still warm in the casket, not yet 2 weeks in her grave, Williams testified at the Haynes sentencing hearing. So, okay, it was 2 weeks later. She stated that she was a gal compliant with gal standards and had received training in child sexual abuse. Williams blamed Mikaela and Sarah for Haynes' crimes because Mikaela and Sarah were conflicted little girls who were overly sexualized for their age.
I wonder why.
She really did write that. I've read the transcripts. They're terrifying. And that Melissa and plaintiff manipulated and fabricated sexual abuse against Haynes, despite Haynes' guilty plea. In May 29th, 2014, Haynes' recorded admission.
Is it really true that in the sentencing that she stated that
Yes.
that they fabricated the sexual abuse, even though he'd already pled guilty to it, and she's telling the judge that the children were making it up?
Yes.
Like, I read in your article that you highlighted that little portion of it, but I didn't get it. The full transcript.
Yeah, I'll pull the full transcripts for you. I have them here somewhere. They may even be attached to this because all the exhibits are here. Exhibit 41, so like where is it? Despite here, document 237, exhibit page 8. So we can go down and look at it.
2 weeks after Mikaela passes away and she's on the stand saying that stuff.
Yeah, it was bad. It was bad. Plaintiff spent hundreds of hours reviewing, researching, and briefing motion to dismiss. The court spent significant resources on addressing the second motion to dismiss, which the court denied, finding that Missouri law did not support defendant's argument. Defendant concealed Williams' GAL file from plaintiff in discovery, relying on Standard 7 of the GAL standards that her GAL file was confidential, knowing Williams was not a GAL. The court relied on defendant's statements that Williams was a GAL, denying plaintiff access to Williams' legal file. Defendants subpoenaed Haynes' prison communications to learn that Williams was in his corner. Oh, footnote number 1. We have an MDoc on May 12th, 2021, probably a recorded phone call from the jail. There were a lot of recorded phone calls. As of May 12th, 2021, and on Haynes' payroll, as of 2019, what? Now that's something I didn't know. Exhibit PL2. I didn't know that. I'll have to look at the exhibit. Using deception, defendants deprived plaintiff of any opportunity to discover Williams' fraud in the underlying cases, and in this case, early in litigation. Defendant's fraud on the court and plaintiff prevented plaintiff from conducting meaningful discovery and caused plaintiff to litigate based on fraudulent facts. Defendant's concealment of Williams' unauthorized GAL practice early in the case has dramatically changed the nature of this litigation and prejudiced plaintiff, causing plaintiff to incur exorbitant legal fees and costs and waste the court's and plaintiff's time. Plaintiff hired a GAL expert, Shelley Reese, to write a report about Williams' action outside her GAL duties, causing significant expense to the plaintiff, deposition preparation, out-of-state travel, and Reese deposition attendance in Springfield, Missouri. On March 11th, 2024, at her deposition, Reese testified she had all her GAL training certificates from 2012 to the present time, as Missouri law required. Defendants filed motions in the divorce court to limit Williams' deposition and trial testimony per GAL Standard 7 in this case. Plaintiff had to brief that motion in the Ripley County Circuit Court, which is always an exercise in futility. Based on the defendant's assertion that Williams was a GAL, the divorce court granted the defendant's motion limiting her deposition and trial testimony, which further allowed the defendants to perpetuate fraud on the court and plaintiff. In every filing with this court, in discovery responses, at Williams' deposition, in Rule 26 disclosure, and in every motion filed in the divorce and juvenile courts, defendants misled the courts and plaintiff regarding Williams being a GAL. Plaintiff had to compel Williams' deposition, which defendants turned into another round of unnecessary, vexatious litigation with numerous motions and objections, causing the court to extend the CMO deadlines to resolve Williams' filings. Defendants abused the discovery process with 93 requests for production, where only RFP 1 through 15 were relevant.
Do you know if there was a motion to compel on those proceedings and whether it was ruled that 16 through, I guess, 93 would have been irrelevant?
I don't know. That's a question for Evita. We should ask her I'm sorry she couldn't be here today. She said
okay.
But that's definitely a question I will ask her. They sought I'm sure she will watch this later, so she'll get back to me with any questions we have. So we should just put them out there for her. They sought plaintiff's attorneys' communication with third parties, demanding plaintiff and Melissa to give them full access to their internet accounts, emails, texts, Facebook, Messenger, login and passwords, text specifications for plaintiff's internet and bandwidth. Defendants subpoenaed plaintiff's Verizon and AT&T telephone text messages and text specifications for plaintiff's internet and Wi-Fi bandwidth and plaintiff's GPS location. And by the way, the plaintiff was living in a off-grid shelter for battered women, and they were still trying to find her location because she was living in a domestic violence shelter, like hiding from this man.
Yeah. Why was she? Well,
go ahead.
Why was she in that shelter? Was this during these proceedings?
Yeah. She had no place else to go. She had to leave Ripley County, and she was worried for her life because Chuck was getting out of prison.
Oh.
He got out of prison during this, and the county wouldn't take his guns. He took her guns and hid them somewhere, and the court ordered that she get her guns back, and the sheriff won't go get them. So now he has access to guns. He was on recorded jail calls making what sounded like veiled threats to end this the old-fashioned way.
There was not a criminal protective order on those grounds ever issued?
I don't think so. I don't think so. No, she couldn't get anything. The Ripley County Court wouldn't give her anything.
What is going on?
So she ran and she went to a domestic violence shelter, and I'm not even sure where she is to this day. He was also threatening her lawyer, and her lawyer, Evita, didn't want to appear in court either. She didn't want to go to Ripley County anymore because she was worried her life was in danger, and the court refused to let them appear by Zoom.
Really?
Mm-hmm. And they scheduled like a hearing right after he got out of prison in Ripley County, so that they had to show up in Ripley County after he got out of prison. A man who is clearly a danger to
Megan. When I tell you that this flies in the face of everything I know about how law is practiced, it's exactly what I mean.
I know.
Nothing makes sense about what you're saying to me.
I know.
To not even accommodate a Zoom visit out of like perceived from an officer of the court saying, "Hey, I'm worried because of these reasons," and say, "No, we need you here."
No, you know what they did to Evita instead? They filed complaints against her license. They're trying to take her license away.
The court?
No, the attorney, the other guardians ad litem and attorneys who she went after and who she exposed. They filed against her now in court.
I would say good luck with that, but the way that's going over there in Missouri, I don't even know.
No, that's what they do. They have a pattern of taking the licenses of attorneys who speak out about this. And it's bad. It's bad.
Missouri, so
yeah. You have nothing to worry about because you're not there in this backwater hell that is the court system in Missouri. Plaintiff exposed defendants' factual fabrications in the Edmondson motions, forcing defendants to correct them and waste the court's and plaintiff's time. On October 27th, 2023, the court issued a detailed order regarding the production of the Edmondson file and its admissibility. Plaintiff complied with the court order and produced the entire Edmondson file to the defendants to stop litigation waste. Having Edmondson's entire file, defendants still filed a motion to compel in-camera review of the email already produced to defendants, again to waste the court's and plaintiff's time. At the plaintiff's January 10, 2024 deposition, defendants wasted hours of plaintiff's time questioning her in violation of the October 27, 2024 court order about Edmondson's irrelevant, unrelated to the case emails. Defendants repeatedly embedded false information into their questions. Plaintiff could only answer these questions if she accepted defendant's falsehood as truth. Defendants wasted hours of deposition time on building false narratives. When plaintiff could not answer, defendants badgered plaintiff and her attorney for pointing out their false facts to defendants. Defendants stopped plaintiff's deposition, accusing her counsel of coaching after plaintiff's counsel said no to yet another abusive question, having endured hours of irrelevant badgering of plaintiff, who was sick, had a fever, having experienced 7 hours of hostile inflammatory questioning, was tired, and unable to comprehend what defendants wanted.
Are those deposition videos out there anywhere floating around?
We have the deposition videos of Charles Haynes, and one of a great YouTuber named Mandy O'Brien. She did a body language assessment of his deposition. It's fantastic. I'll send it to you. And we have his deposition, but not hers. I don't have hers yet. I'll ask and see if we can get it. You'll love Chuck's though. Chuck's is unbelievable. Chuck Haynes.
That one.
I always love a good bad deposition.
Deposition's going wrong.
Oh yeah, deposition is great. It's absolutely incredible. In fact, actually, hold on. Let me see if I can pull, because there is a. Let me go over to YouTube. So she goes by Body Language Ghost now. Body Language Ghost. Charles Haynes. Oh yeah, here it is. Okay, so. Let me put in so you can see this guy in live time. Let's see, stop screen, present share. I got this one part. I think I can find it pretty easily because of his facial expression. This one part is unbelievably good. So this is Mandy doing her assessment of Charles Haynes and his body language during this deposition. And the lawyer who is deposing him is Vita Tolu, who's Cynthia's lawyer. He makes this one face. Where is it? It's so freaking funny. She calls it the oh shit face. And it's so clear. It's got to be here somewhere. Where is it? It's so good.
Good to see that he came dressed for the occasion.
Well, he was in jail.
Oh, okay.
This is in jail. In
that makes
jail.
sense, I guess.
That's quite a face right there.
Looks like a hard-boiled egg.
There's no audio if you're...
Oh, what? Wait, there's no audio?
Oh, I thought you were doing that on purpose.
Wait, is there no audio? What happened?
Yeah, there was definitely no audio.
Oh, I'm sorry. Here we go. No, I'm not doing that on purpose. I'm trying to find the oh shit face because it's so freaking funny. But here, we'll just let this keep playing. Let's see.
Which various is happening. But to all the normal people out there who don't make a habit of being a pedo and hiding from people, this makes no sense.
Well, its previous attorney or the other attorney or the other 5 attorneys that Cindy's had.
No.
Nobody sitting here was in the case other than Chuck at the time she was appointed.
And that's why I'm asking.
And if he doesn't know how she was recommended or appointed.
Well, I know how she was recommended. I just want to know if Chuck knew how she was recommended. So, how many times did you and Jennifer and the girls meet?
Once.
How many times did you and Jennifer meet?
Just that one time with the girls.
You never met with her after that?
Nope.
How did you communicate with Jennifer?
I didn't communicate with her. I mean,
Honestly think this part is actually the most honest there is. I didn't communicate with Jennifer. He actually had some movement there. which would make more sense in the personality realm that he does not have a relationship with this Jennifer lady. Now it just makes you sit there and think, well, who was his attorney and what kind of relationships did he have? Because I can imagine, a situation like this going up. Oh, don't worry about that. We're going to get this lady in. Oh, we're good friends. Don't worry about it. It's all good. Shoot, she might even, say a good word for you for the judge. And then life is good.
We had lived in the office, the log house.
All right, I think the oh shit face might be right around here. I think I found it. Let's see. Oh yeah, this is funny. This is so funny.
I think it was. I think it was over. Over her having an affair, and I confronted her over it, and Cindy.
So this is really slow to get through, but this is that part of trying your patience in hopes that you'll just, take the first thing that comes out of his mouth and stop talking to him. Move on. He seems non-aggressive. By doing that, he seems like an invalid, someone you wouldn't have to fear. It garners sympathy from the SJWs. Oh, he needs help. He's used to getting that response. And anybody who's got any sense gets very impatient with him and just moves on. And so shall we.
So,
Isn't she funny? Isn't she funny? Yeah. Do you find that sometimes in depositions where people are just trying to time waste on you? And
yeah, but you know me, I don't let it go.
Yeah, no, I know. You're pretty good at that. You're very good at that.
Yeah, I'm just asking the same question 10 different ways.
2015. Did your mom have a computer at home?
When was this?
From 2013 to 2015.
Did she have a computer at home? Yes.
Did you use it?
Rarely.
And my understanding is that computer is with the Butler County Sheriff's Department.
Oh,
there it is.
It was turned over to the prosecutor.
Why?
Because supposedly there was pictures on there.
Oh, shit. He knew those were the words that he wanted to bring out of his mouth. Oh, it's not mine. Bug-eyed, stress in the face, trying to get away from the situation by literally pushing himself away. Guess he wasn't counting on that.
Isn't that something? I mean, yeah, that was the oh shit face. Okay, so that's out there, and I can send you links to all that stuff. But this is, if you guys in the chat, if you want to watch the body language analysis of Chuck Haynes, I'll throw that in the chat for you to watch later. But yeah, so we'll get back over to the. But that's the guy we're talking about here. A real winner. One of life's real winners, folks.
We can't all be winners, as they say.
All right, let's see. Let's move this over here.
He does, however, sound a lot like a South Park character. Just his mannerisms. He sounds like the stereotypical, like, creepy guy that's like warning you about the cursed haunted house.
Yeah. Elephant wants to know, did they catch him with CP on his computer? Well, allegedly, yes, but the prosecutor, and they never added more charges.
Why would they not?
I don't know. And the computer disappeared.
Is he
7 years. He got 7 years, but he got out in 5, I think. Awful. Let's see. The following day, the defendants motioned for the appointment of a special master to preside over the plaintiff's deposition, accusing the plaintiff's counsel of coaching. The court denied it, suggesting that defendants substitute counsel Diamond for another attorney. The deposition was rescheduled to January 16th, 2024, during which plaintiff endured another 9 hours of badgering and legal waste, during which defendants forced plaintiff to listen to her and Haynes's prison call in its entirety over 30 minutes long. Plaintiff incurred legal fees and wasted time and financial resources due to the defendant's deposition conduct. Plaintiff went to great lengths to depose Williams, even after the court ordered it. Defendants rescheduled it after plaintiff spent hours on the phone with the court clerk to schedule it on December 21st, 2023. Defendants rescheduled Williams' deposition for January 17th, 2024. Several days before January 17th, defendants again wanted to reschedule Williams' deposition. At her deposition on January 17th, Williams testified that she was a Missouri certified gal for the years in question. She had 100 cases when she was appointed as a gal in the Haynes divorce, and that she had provided all gal certifications in my possession to my attorneys shortly after the lawsuit was filed. Williams did not tell plaintiff that she never obtained gal training for 2016 through 2021 and therefore did not have the records in her possession. Plaintiff asked Williams, "Looking back, have you thought what should have been done differently to save a child's life?" And Williams said, "I believe that I did the very best I could to advocate for Mikaela and Sarah's best interest. I will testify here today that I did the very best that I could to advocate for their best interest." Placing Mikaela with the self-admitted and criminally charged rapist for Mikaela to be raped and then silencing Mikaela after the rapist sodomized and raped her, threatening to return Mikaela to the custody of her rapist, was the very best that Williams could do to advocate for Mikaela's best interest. Damn. Damn, Evita. Well, damn.
Yeah. That was one of those where it's not scoring points for your motion, but you just want the judge to know.
Yeah. Defendants repeatedly objected to deposition questions, needlessly disrupting Williams's testimony and wasting plaintiff's time and financial resources, evident from a few pages of Williams' transcript. Because plaintiff relied on defendants' false statements to the court, plaintiff and defendants' concealment that Williams was not a gal during discovery, plaintiff's deposition of Williams was wasteful. The court ordered this case to proceed to mediation on October 31st, 2023. Plaintiff provided her names of the potential mediators on November 1st. Defendants refused to agree to the mediators proposed by plaintiff and name their mediators. Plaintiff had to ask the court to extend the appointment date for the mediator selection to December 15th. After days of negotiation and an exorbitant waste of time and resources, on December 14th, defendants agreed on the mediator only if plaintiff agreed to continue Williams' deposition to January 17th. To comply with the court order, plaintiff was forced to continue Williams' deposition after the plaintiff's attorney spent $1,500 on airfare, sent notices of deposition, secured the courtroom for deposition, and rescheduled her other legal matters. 2 days before the scheduled mediation, the mediator canceled under suspicious circumstances, forcing plaintiff to agree to the mediator forced on her at the last minute. Plaintiff spent significant time and resources to draft a mediation memorandum, prepare and attend the mediation, paid $1,000 to mediate. The mediator communicated defendant's offer of a token settlement. "Go away, what are you doing here? I know you're broke. Just take what is offered and leave. You have major problems with your case." Footnote number 2. Let's go
Is that
down
a
there.
quote from the actual mediator?
I don't know. It says, "The mediator probably alluded to Eden's affidavit and the defendant's soon-to-be filed third motion to dismiss." Well, it's in quotes.
Yeah.
It's in quotes. So you will not get anything from them. The bar plan is in the business of making money, not dishing it out. Just go away. Trust me. And this is exhibit PL12.
Huh.
So apparently it's in the exhibit. When plaintiff went to the bathroom, she saw the mediator's hand on Collins's waist while the entire group of attorneys were laughing. Seeing it, plaintiff cried and vomited in the bathroom, insulted and humiliated by the process for which she had to pay, and took time away from work and family to attend. On February, again, this is that, it's an old boys club and you're not in it.
Yes.
On February 21st, defendants filed a third motion to dismiss, claiming that plaintiff was not a Georgia citizen, relying on the affidavit of Chris Eden, which defendants obtained from Eden on May 23rd, 2023, posing as Haynes's attorneys. This is something I had not heard before. I have no idea what this is about. On January 17th, 2024, defendants did not mediate in good faith, having obtained Eden's affidavit on May 23rd, 9 months prior to the mediation, knowing they would file their third motion to dismiss. The defendant's mediation, conducted in bad faith, forced plaintiff to incur legal fees, costs, transportation, hotel experience. Yeah, blah, blah, blah. Defendants tampered with Eden from February 1 until May 23rd when Eden signed the affidavit for Haynes' attorney Collins. In February 2023, Eden texted Melissa, "I have no problem lying about you not residing in Palmetto or anything I would need to confirm to destroy you in federal courts."
That was texted to her?
That's what it says. "Once I give Collins my deposition next week, it will be too late for you. Don't make me waste my time and more money to come testify under oath to punish your mom for your cases in courts. Check with your mom. She knows about Palmetto and all her recent filings. It's very important your mom's address on her federal filings, specifically residencia, must be important to Chuck's attorney, Mr. Collins. If they are willing to pay for my flight and expenses to Missouri," and there's an exhibit, page 54. Defendants bribed Eden with 2 fully paid trips to St. Louis in exchange for his affidavit. The plaintiff had no residencia in Georgia. When plaintiff asked about Eden's affidavit in the March 26, 24 meet and confer, Collins said, "I'm not sorry about how I handled the situation," Exhibit 13, "and I'm defending my client as I'm required to do, and I will continue to do that without apology," Collins said. "You made very scandalous allegations against the defendants in this case." Plaintiff's counsel replied, "Scandalous? They killed a child." Plaintiff asked defendants 3 times to withdraw their 3rd motion to dismiss, with Eden's affidavit obtained under troubling circumstances. Collins refused to investigate plaintiff's bold assertions.
I'm like flabbergasted that there is a text message that says that I'm going to lie on the stand and say whatever I got to say.
I know.
Why would you put that in a text?
These people, here's the thing, Omar, there's never any accountability for these people. They're all involved in the same court system and they're in it. The judges are with them.
That's kind of what I'm getting at. Like the boldness of you putting that in a text message kind of just says it all.
Right. And the only way to get any accountability, by the way, is to get this stuff to a higher court.
Yeah.
Because every time you're in Ripley County Court, they rule against the plaintiff every single time. I mean, it is just outrageous. It's
maddening.
It is. It's maddening. In May of 2023, defendant's agent Michael Barbary falsely posed as law enforcement to McKenna Summerfield and Leah Brandon, who knew Mikaela and Melissa and plaintiff, to collect dirt on plaintiff, Mikaela, and Melissa under false pretenses. Plaintiff questioned defendants about their unethical self-help discovery, who told plaintiff it was Barbary's standard practice to collect evidence in this manner. Defendants repeatedly delayed adjudication of this case, seeking CMO amendments and extensions to file their pleadings, wasting the court's and plaintiff's time and resources. Defendants misrepresented the facts in their filings, forcing plaintiff to file corrective pleadings and expend significant time and resources on addressing defendants' misstatements of facts and law and the court to address filings. And here's all her proof. Look at all these filings. Jesus. Look at it's a paragraph of documents, you guys. And Avita's doing this pro bono. She's not getting paid for this kind of work. On March 7th, 2024, late afternoon, Collins contacted plaintiff's counsel to cancel Dr. Marks. You guys know who Dr. Marks is. We read that Dr. Marks was Mikaela's psychologist who was like, what the hell is going on here? This is witness tampering. You're driving my client to depression. Stop it. Collins contacted plaintiff's counsel to cancel Dr. Marks's deposition scheduled for March 8th, 2024. Collins told plaintiff's counsel that the defense team had depleted the bulk of the already small wasting insurance policy to pay the defendant's legal fees and would burn through the rest before trial. "We can throw some change to you to dismiss the suit," he said. Dr. Marks appeared for his deposition on March 8th, 2024, and so did plaintiff and her attorney, because they could not reach Dr. Marks the night before. Plaintiff incurred attorney's fees and wasted 1 workday. This court found that the defendant's cancellation of Marks' deposition was untimely and ordered defendants to pay Dr. Marks for the wasted workday. On March 26, 2024, the parties had a meet and confer. The defendants refused to agree to plaintiff's request for additional time to respond to their 3rd motion to dismiss and misrepresented to the court what happened at the conference opposing plaintiff's extension. Defendants posed plaintiff's counsel as non-cooperative and misstated the content of the meet and confer conference. When plaintiff's counsel questioned defendants about their concealment from the court and plaintiff that Williams never had GAL training, Collins said, "I have the same duty to vigorously represent my clients that you do. You don't seem to appreciate that." Attorney Diamond claimed Williams was not required to have any GAL training certificates. Footnote number 3, GAL Standard 14 requires Williams not only to have certificates of her GAL training, but completion of the training hours shall be documented by affidavit or evidence filed with the appointing court by July 31st of each year. Defendants accused plaintiff's counsel of perjury, which the court found unsubstantiated. On April 10th, plaintiff asked defendants to withdraw their misleading statements made to the court. Defendants did not. Instead, defendants continued personal attacks on plaintiff's counsel, forcing the court to issue a warning. Defendant's counsel is warned that if he does not cease engaging in these sorts of unprofessional and offensive attacks, he will be sanctioned. The court will not tolerate such conduct in the future. In this litigation, defendants were represented by 5 attorneys and 2 paralegals. Defendants sent plaintiff 437 emails. Plaintiff replied 300 times. Plaintiff exchanged 737 emails with her attorney, witnesses, experts, court personnel, and court reporters to expeditiously comply with CMO and discovery to prosecute her case. 1,574 emails were written to address legal waste defendants precipitated. Some emails had voluminous attachments, but even if each email and response is billed at the lowest rate of 0.1, plaintiff incurred $59,025 in legal fees at her hourly rate of $375 an hour. To address defendants' legal waste, 5 attorneys and 2 paralegals made plaintiff's attorney work full-time and overtime on addressing their filings, scheduling depositions for defendants' witnesses, organizing mediation, communicating with experts, engaging in various conferences with defendants, and wasting time in obtaining deposition transcripts from defendants while accused of perjury. From January 18, 2022 until the present time, defendants monopolized plaintiff's counsel's time exclusively and needlessly, depriving her of any other meaningful income-producing opportunities and forcing plaintiff and her counsel to incur substantial debt to fund litigation based on defendants' fraud on the court and plaintiff. Argument. Rule 1 of the Federal Rules of Civil Procedure provides that the rules shall be construed to secure every action's just, speedy, and inexpensive determination. 3 fundamental goals underlie this mandate: maintaining the quality of justice, avoiding delay, and improving the efficiency of dispute resolution. To secure these values, courts recognize that judicial resources are limited and must be protected from wasteful consumption. Litigants have a right to be free from harassing, abusive, and meritless litigation. Federal courts must exercise their authority to protect litigants from such behavior. Defendants caused Mikaela Haynes legal abuse syndrome, a subset of PTSD. Footnote 4, and there's some links to what that is. Mikaela took her life unable to deal with the courts anymore after she lost the ability to defend herself from the defendants at the moment Mikaela needed the most. Haynes raped and sodomized Mikaela. Williams and Spain Miller, unscrupulous lawyers, abused their authority to drive an innocent child to take her life. Defendants continued unapologetically the same abusive conduct in this litigation, to destroy plaintiff emotionally and financially, forcing her to abandon the case while defendants depleted already small wasting insurance policy for their enrichment. Defendants waged personal attacks on plaintiff's counsel to drain her financially and emotionally, hoping that plaintiff's counsel would drop plaintiff's case. Plaintiff seeks the court's protection, recovery of her attorney's fees and costs, striking defendants' pleadings, and imposing discipline on defendants and their attorneys. Defendants multiplied these proceedings in bad faith. Plaintiff is entitled to her attorney's fees and costs. Plaintiff moves the court for attorney's fees under 28 U.S.C. 1927. Footnote 5. Any attorney or other person admitted to conduct cases in any court of the United States or any territory thereof, who so multiplies the proceedings in any case unreasonably and vexatiously, may be required by the court to satisfy personally the excess costs, expenses, and attorney's fees reasonably incurred because of such conduct. Under 28 USC, a court may require counsel to satisfy personally attorney's fees and reasonably incurred by opposing party when counsel's conduct multiplies the proceedings unreasonably and vexatiously. Section 1927 warrants sanctions when an attorney's conduct viewed objectively manifests either intentional or reckless disregard of the attorney's duties to the court. And a bunch of case law. Defendants concealed that Williams was not a gal from the divorce and juvenile courts, that she was not a gal at the time of her appointment on May 6, 2016, and reappointment on January 30th, 2017 was in bad faith, vexatious, and aimed at the multiplication of litigation in violation of the code. In this case, defendants' attorneys consciously decided to continue the perpetration of the earlier fraud, disregarding their duties to this court, the divorce and juvenile courts, and plaintiff asserting Williams was a gal and seeking to limit Williams' testimony in this case. Plaintiff relied on the defendant's fraud in the divorce and juvenile courts, the conduct that drove Mikaela to suicide. Defendants and their attorneys defrauded this court, and plaintiff vigorously and unapologetically forcing the court to waste precious time and plaintiff to incur exorbitant legal fees, expenses, and waste time. Plaintiff learned with one phone call and an email that Williams was never a gal certified to represent Mikaela and Sarah's best interests in the underlying case. And the exhibit is here. And she was never immune because she procured immunity, concealing that she never was a Missouri gal. Defendants procured the Eden affidavit, impersonating themselves as Haynes' attorneys, knowing that sexually deprived and disgruntled Eden had no problem lying about you not residing in Palmetto or anything I need to do to confirm to destroy you in federal courts. Defendants have no remorse for how they handled the situation with Eden. Instead, they accuse plaintiff of making scandalous accusations, perjury, and trying to stir the pot. Defendants accuse plaintiff of conduct they perpetrated vexatiously, multiplying these proceedings for 2.5 years while wasting the court's time, draining plaintiff's emotional and financial resources recklessly without apology. All right, so I think we can probably skip through this part. Frivolous, yeah, we get it. Plaintiff is entitled to her attorney's fees and non-monetary sanctions per the court's inherent powers. Because this is more repeat of the background, so I'm going to get through this. Okay, so this is the end of it. She's claiming Rule 37 violations as well. And then we get to the exhibits, and there's a conclusion and then the exhibits. So I think we got the idea of what this is, right? We probably don't.
Yeah.
Oh yeah, it's 229 pages. Now this is where the exhibits start. There's transcripts, there's all kinds of stuff which we won't be able to go through on today's program. Obviously, there's just too much here. But I will send this to you so you can actually take a look at it when you have some time.
Yes,
if you want to look through the exhibits and stuff and see what you find, because this is incredible. Look at how many, look at this.
Well, there's no chance at this point that I can't cover the case. I have to talk about it now. This case is wild. It's unlike anything that I've ever been involved with. I know that there are these communities that exist out there, the old boys club and the CPS club and the dependency court club and the whatever club, but to this degree is crazy. Like, there are things that are happening in this case that make me feel like I just don't know the law well enough to understand what's going on. But it's not that. It's just simply that the principles that those laws were legislated, there's literally laws in place that you have described that are supposed to protect these children that are just being ignored.
Yeah.
I can't get over the fact this lady's was so persuasive in a case when she wasn't even a licensed guardian at Litem. And then the legal reasons that she stated for her findings were not, what was the term that she used? Red lightable or highlightable or something? Hotlineable issues, but we're going to do it anyway, even though he's standing trial for something that would make him ineligible for custody.
Yep.
They don't make sense to a reasonable person, which just, and the fact that, I don't know, maybe I got to go back and read that again, but they're literally placing in text messages statements to plaintiff that they're going to perjure themselves and say whatever they have to do to lie on jurisdictional issues in an
I know, it's
upcoming hearing
crazy.
in
I
the
can get
future.
I can connect you with Avita Tolu, the attorney on this case, and she'd be happy to talk to you about it because, you know, she's been screaming into the wind for years on this now, begging people to start reporting it. There was one local reporter in St. Louis that did start covering the case. It was like a law review in St. Louis. I can't remember the name of it now. So it's me and that one person in St. Louis who covered this case. And it is so outrageous, the things that have been done. It'll blow your mind. This is the worst one I've ever heard of. The worst. And I've heard some bad cases. This one is the worst. The tactics that his lawyers are using, it shouldn't be allowed. It is illegal. It actually, like, she went over the federal code. It is illegal, but they keep getting away with it.
Megan, at what point, if you were, okay, let's just say that you were a lawyer and you have to question one of these children making allegations in this case, at what point would you feel comfortable saying that the child was lying because they're being coached by the main parents?
I guess if at what point would I be comfortable? I would say that if the story changed, you know, several times,
But they
if you're
change a
getting,
lot. I'll give
if
you an
you're,
example. I'll give you an example. I tried a case where there was three children claiming to be the victims of a sexual assault at the hands of, they would have been 10, 12, and 13 at the time. And the claims were that the creepy uncle comes and basically molested them all at a family party while there was others in the room. Their stories changed multiple times and they gave wildly inconsistent statements while they were on the stand. And I was having to cross-examine them, representing the guy that was accused of doing all of these things. Every single one of the children, and you imagine how careful you got to be when you're cross-examining a child. It wasn't like when I was cross-examining you when you were, what's her name? It was me just basically asking a question like I was Mr. Rogers. Tell me a story. So what happened on this date? And I'm basically just trying to get them to retell their story and highlight any inconsistencies, like what would be your instinct. And the jury in that case did not believe, well, they hated my client, but they believed the children anyway, which brings up this point. It's very difficult for lay people that are not involved in the system to disbelieve children because they all say the same thing. Why would a child make it up?
Yeah.
And on the other hand, I have judges telling me, well, children say things all the time. And they're coming from two different perspectives. Like from the one, like we hear false claims all the time of domestic violence, of child abuse, of child neglect, of fake pregnancies. We hear that kind of stuff all the time. And so it makes us very jaded. I told you my story about the first trial I ever did where I literally acquitted a guy, 100% believing his story, losing sleep over it for months of my life because I was so nervous about this guy going to prison for 22 years. And then only after the end, after his acquittal, to walk out of the courthouse, say, hey, Omar, I did that shit. I was guilty. And so
wow.
At what point are you willing to stand in front of a court and tell or recommend to a judge that, hey, the kids are making it up? I think there's coaching.
I don't know if I can answer that question, but I'll tell you the question I can answer. And that is, at what point do you believe a child? I can answer that one easier.
No, I could answer that one too. I want to hear your answer. Then I want to give mine.
All right. I will use the Mikaela Haynes case as an example. When Child Services is telling you that it is a valid concern, that they are concerned about child abuse, that's one indication, and they did in this case. When doctors refuse to let her go back to her home where she has been placed with the grandmother because they are concerned there's abuse going on there, and that her behavior, her cutting behavior, was a symptom of that abuse. Yeah. When the child herself is telling you she does not feel safe in that environment, it's a combination of things, right? You have professionals saying, her psychologist, okay, that's number 4. Psychologist is saying she is not safe in the care of her father. Every available professional besides the guardian ad litem is in lockstep saying she isn't safe in this place. Even the guardian ad litem herself admits Bernice Haynes is not a good supervisor.
Yeah.
And everybody knows her father is a convicted child rapist. How much more do you need in that to believe the child in this case? The guy served a 5-year sentence for this behavior.
Well, my normal answer would be that's one of the easy cases because you don't ever have all the experts agreeing like that. In a case
Right.
where you do, that's like an open and shut. Well, obviously, this guy's not going to have any visitation until we sort all this out. And he was literally on trial I don't know if he was convicted at that point yet, but
He pled guilty.
yeah.
So, yeah.
But yeah, that should have been an easy open and shut case.
It should have been. But for some reason,
I got to tell
it
you though,
wasn't.
it's not so easy. The fact that CPS makes findings doesn't necessarily make it an open shut case in my
No, I agree.
experience.
If it was just them, I would have a hard time. Okay, if it was just
Yeah.
them, I would have, because believe me, I cover lots of CPS corruption as well. They make up a lot of shit all the time.
Yes, they do.
That's no doubt. But I mean, we had in this case recorded conversations of the social workers in a room with Mikaela, like clearly seeing that this is going on, like something is wrong, and believing her and hearing her and being like, we don't understand why this is going on. Like we don't get it. We don't get why there's this push to give him access to her. I mean, you're right though. It's not easy most of the time. It can be very complicated, but I think children should be believed unless there's some evidence that you shouldn't believe them. I
I'll
think
give you a recent
especially
example.
if the child is an age like 14.
Yeah.
14? Look, even if a 14-year-old is making it up, there's a reason she doesn't want to be with that man. So maybe just give it to her and let him work out his relationship with his daughter. And like whatever went wrong there, like that's for you guys to figure out. But like we're not
Yeah.
going to force a 14-year-old to go live with one parent that she says she feels unsafe with when she feels safe with the other one. Okay? Like she's 14. We let 14-year-olds get abortions without parent consent, but we don't let them choose which parent they want to live with. That's insane.
Usually in California, there's not really like a set age, but typically it's around 16, basically about to be done with childhood and graduate high school. I'll tell you what, I have a couple of cases, recent cases. Put it this way, I've had hundreds of cases where children are saying they don't want to go with other parents.
Sure. It
But
happens a
here's what
lot.
happens. Here's what happens. Not in this case, because this case, like I said, should have been easy, but you get a lot of bullshit cases where it's like, I'm not sending him with dad because my son is terrified of him. Why is he terrified of him? Well, I don't know, but I'm not going to force him in the car to go because obviously dad is doing something to make him afraid. And then CPS will go and they'll investigate and like, well, I mean, the allegations are inconclusive. And they'll take him to a therapist and the therapist will say, well, there might be something here. And then the judge will be like, look, you're going to have to follow the orders. You can't let the child dictate whether or not he gets to see his dad or not. And they say that like 90% of the time, unless you have like multiple findings by experts saying that, oh, there's definitely something here. It's really hard to get a judge to deny access to the other parent. There has to be almost uncontrovertible evidence, like you should have had in this case. So when you tell me that you have this guy's literally about to go to trial, they got the doctors saying that there's an issue here. You got CPS saying that there's an issue here. You got the statements of the children, multiple children saying thing, and saying stuff. And then the illegal guardian ad litem is stating, well, her grades are not that great because she's homeschooled. And so I think it's in the child's best interest to spend 5 hours every Sunday or whatever it was with a rapist. It knocks me out insofar as I don't understand any legal reasoning that would justify that. I mean, I get angry with my own cases because I don't understand the reasoning in some of my own cases, but this one is just in a completely different universe.
Well, that's Missouri, a completely different universe. Once you start reading about some of these cases I've covered there, it will blow your mind. And those of you in the chat, if you want to see my entire Missouri catalog, I'm going to drop it in the chat for you. Also, the Mikaela Haynes story is linked in the description, and you can you can certainly find out about it there. But I have all 29 of my articles listed at this one link that I just dropped in the chat. There are so many different stories of parents fighting the corruption that's going on there. And it's a big money-making scheme. What happened in Missouri is that the guardians ad litem use certain court psychologists, and they always use the same ones. And one of them was James Reed, who happened to be married to a sitting presiding or a judge who was retired, and then he was doing mediation. So the guy is married to a judge and also doing these court-appointed cases. And you think that he's not getting special treatment with his, opinions, or not getting special treatment when he's married to a or like one of the most respected judges in the St. Louis court system, who still has
being disclosed before every case starts that there's like that conflict of interest?
No, I found that out during my investigation. The guy's married to a retired judge who's still in the process of like doing big time mediations and making huge money. And they're all connected. They're all making money off each other. So they appoint this guy, James Reed, to be the psychologist. And then he diagnosed Evita Tolu with a bunch of personality disorders she doesn't have. She goes to another psychologist, gets a clean bill of health, submits that to the court, and the judge goes, we believe James Reed.
What?
You don't get your kids. Yeah.
Wait a minute. James Reed, who is he again?
He's a court-appointed psychologist who is supposed to do custody evaluations, and he cost $30,000. Evita had to pay him $30,000 for the pleasure of being diagnosed with borderline personality disorder and other unspecified personality disorders that she doesn't have.
That's wild.
And they actually reported on this on Channel 8 in St. Louis. They actually did one report, and they never followed up, but they did a report because all these women were coming forward to say, this guy falsely diagnosed me with borderline personality disorder to remove my children and give them to their fathers, who were abusing them. Some of them were abusing them. Some of them just, won the case because they paid more money or whatever. And then they're forced to pay hundreds of thousands of dollars to these court-appointed professionals. It is crazy. And James Reed, he diagnosed like 16 women in the St. Louis area with borderline personality disorder. And when you break it down to the borderline personality disorder is like a pretty rare thing. When you break it down by the numbers, it's like St. Louis is a hotbed of borderline personality disorder. And they're all James Reed's clients.
Yeah.
Yeah, it's incredible. It's incredible. So the other news that I have that I didn't get to was that Evita gave me, let's see, here it is. So Evita said there was some good news. She said all the hard work we did wasn't in vain because they finally implemented standards. On February 1st, here, let me pull this up. She said they finally implemented standards for guardians ad litem in St. Louis. Family Court of St. Louis County planned for implementation of guardian ad litem standards February 1st, 2024. And this was something that we had been fighting for to make sure that they couldn't take advantage of the system and make so much money. At one time, Elaine Pudlowski, who was a guardian ad litem who was featured on that leaked Zoom call, had 80, you're not going to believe this, 80 different cases open in the month of December, 80 trials.
Yeah.
80 trials. She made $250,000 that month on those 80 trials, 80 cases.
Just because you have 80 cases, I mean, you're doing 80 trials. But then I read they were
court dates.
Trials.
Court dates.
And like basically just on the pleadings, making judgments.
Mm-hmm.
Not how, that's absurd.
It's absurd. So they have now, because of the work that we did, they have put into an effect that there is now a cap on what guardians ad litem can be paid, and it's a flat rate now, whereas it was hourly before. It's now, I think she told me it's $2,100, and if they want any more money, they have to go and plead their case before the judge. In Evita's case, I think she had to pay Elaine Pudlowski something like, I don't know, it was like when it came all together, it was somewhere between $15,000 and $25,000, I want to say. to be the guardian ad litem on her case. If it was Elaine, it might have been another guardian. There were a lot of guardians involved, but Elaine had a lot of them. I think in another case that I followed that Elaine was the guardian, she got 20 to 30,000 for one case. So
How
now
much
it's
is paid by the county?
none of it is paid by the
Really?
county. They force the parents to pay for it.
What?
Uh-huh.
the hell?
They bankrupt people. That James Reed, the doctor, $30,000. His bill was $30,000 for his psychological evaluation.
Is there like a defense? Like, hey, we don't have the financial wherewithal to pay a guardian ad litem. I need relief from the court. They don't have that mechanism.
You can, but you know what they do? They strike your pleading. They strike all your motions. The judge just throws out your case basically, and you lose. You automatically lose. And the very first thing they do is they look through your financials. So if you are if you have any money, which Evita did, because she was an attorney and they had money, they know how much you have. And strangely enough, their bill always comes up to the amount of money that you have. And they take all your money.
How much do they bill an hour for these guardian ad litems?
Oh, I don't know. That's a good question. I'm sure I came across it at some point. It's insane how much. So they did finally implement that they have to have certain standards and qualifications. The biggest thing that happened here was the flat rate. That is going to not allow them to make the kind of money they were making on their Cash for Kids scheme. So hopefully it will keep out the bad people who want to take advantage of families and children and make money hand over fists on destroying families. Hopefully it will stop some of that.
Well,
We will see.
Expedite things, but I think it's going to force. Honestly, when you do stuff like that, it's going to force the guardian ad litems to rely more heavily on the opinions of experts, which could have its own set of evils attached to it.
Well, that's another thing they need to do is put a cap on the court-appointed experts. And also, I don't think there should be any court-appointed experts. I think that if the court's going to require a psychological evaluation, then the person who's getting it needs to be able to choose their own doctor. As long as they're an accredited doctor, I don't understand why that's a problem. Why should someone be prejudiced by using the court's favorite psychologist?
Well, I talked about that a little bit when I was covering the Kowalski case. That lady had been, who was she? Darth Vader. You had a sound for her.
Oh yeah, here it is. It's right here. Sally Smith.
Sally Smith. Didn't she been there? Wasn't she there for like over 20 years or something like that? Some absurd amount of time.
Oh yeah.
And she was basically just like paperworking everybody through and just chattering. My argument was like
300 cases, 300 cases at least that she went.
You can't be there for that long without like being jaded or forming opinions, or like she was doing with Kowalski, making her out to be like the bad, crazy mom, and we're not doing this and keeping her out of the hospital and those kinds of things. My thought was maybe we should just like cycle in, maybe get like a year or two. We'll call it like public service, use it to write off your student loans or whatever. But so you're not getting all burnt out or developing these deeply ingrained relationships with public officials or judicial officials that's affecting the lives of children. It seems like an easy thing that they can do, but they don't. And they let Sally Smith's, because I had even argued there must have been a time when Sally Smith was not Darth Vader and she was genuinely there to help children, and she went to law school, or she did whatever she did. She got her training, and
She's
she
a
had the best
doctor.
of intentions. Yeah,
Child abuse pediatrician. Yeah.
right. And then at some point, it just became too much, and she became burnt out, and then she was no longer participating.
I have a different theory about Sally Smith. I think based on her character and her just her track record, I think she's one of these people who got a God complex after a while. And she became drunk on her own power and authority. And she is a person who does not like to be told that she doesn't know something. And she's going to teach you a lesson if you try to tell her you know better than she does. And I think that is what happened in the Kowalski case. It's what happened in the other cases that she's involved in. Do you know about the other case Greg Anderson is doing that is involving Sally Smith? she tested, one of the woman testified at the Kowalski trial. God, what was her last name? I'm going to forget
there
now.
like 12 other cases that was involving Sally Smith? Which one was she?
Oh, there's 300, but she was the one. There were some the ones that USA Today reported. This family, the Kushner family. Sally Smith did the same thing to the Kushner family, and Greg Anderson is representing them as well. And so there's another lawsuit coming down the pipeline against Johns Hopkins and All Children's and another hospital that she was working at the time, and Sally Smith. So it's going to be pretty interesting to watch that. I have a couple of videos on my channel about the Kushner case. I interviewed Greg Anderson about that, and we'll be keeping up with him on how that case is going. Right now, it's stuck in an appeal. It's a whole thing. They're involved in the brain injury program in Florida. And so they are now appealing a ruling in that court for this, and they can't do their civil suit until that is resolved. And so that's against this state program, and it's a whole long story. Omar, I have to get going. I got to let you go. I've got to take kids to doctors and stuff today, but I want you to tell everybody about your channel and what you do over there. And Mods, while he's doing this, I want you to make sure that you post the Tilted Lawyers YouTube link so everybody can go over there and like and subscribe. So Omar, tell people about your channel and what you're doing over there.
Well, thank you for the impromptu. Let's just go around the circle and tell everybody about yourself. But no, I'm Omar Serrato. I have a YouTube channel. It's called The Tilted Lawyer. People ask me all the time, like, what's the deal with the Tilted Lawyer? Like, why are you so tilted? What does that even mean? It was when I was trying to figure out a name for my YouTube channel. It's like a chess term. So you get to playing like all of these chess games, and sometimes you become so rattled, like you're not really thinking about the moves and you're just kind of all over the place. And they call you, when you're in that community, you're tilted. It's like, yeah, I'm the Tilted Lawyer. That's what I am. Because at the time, I was going through all kinds of crazy cases, and it just kind of stuck. But we cover a lot of cases. We've been doing a lot of true crime stuff. More recently, we've been talking about the Laura Owens case. We were at a point talking about the Karen Reed trial. And generally, we don't post every single day because I am a practicing attorney, but usually on Fridays or so, sometimes Thursdays, I'll go live. And we will do these shows. I just had Megan Fox, and we did like a mock cross exam, and that was a lot of fun. Everybody really liked that. And by the way, everybody thought that you won me.
It was really fun. I actually did not realize how badly I wanted to do that until you suggested that we do it. And then it was like, oh my gosh, this is such a great idea. We should do this all the time. In fact, I had people contact me and say they want to do an entire mock trial and bring Dave Neal in as Clayton, and
amazing.
Have Jeff, my other friend Jeff, who's an attorney, have Legal Vices play the part of David Gingras, and have you do a Woodnick again and see how that goes. I think it's a great idea. I love it. I absolutely love this idea.
I've done that. I did that with you off the cuff. I've rated myself. I was like, yeah, I'll give myself a C. Like
I think you did pretty good. I think you did pretty good for not being involved in this case as long as we have been. There are things that we know that you couldn't possibly know because it's so voluminous, right? The information is just crazy. But yeah, I think we should consider doing that soon.
I'm in. If people want to do it and people want to see it, I am 100% in. And then
cool.
I think that you have acting chops that you weren't aware of, or maybe you were, because everyone's like, "Oh my God, the facial expressions were spot on."
I was a theater major, so I do have acting chops. I did acting in college at ASU, where David Gingras went.
Well, you did really, really well. When I tried that the other time, I had my assistant Melissa play Nicole Kessinger, and I almost made her cry. And I did it with her. You were much more formidable and resilience on Cross, which was a lot of fun.
Yeah, I actually love being deposed. I was deposed one time in a court case that I was in Illinois, and my attorney afterwards, I'll never forget it. We walked out in the hallway, and I was like, "How was that?" And she goes, he's never going to forget that. That guy is never going to forget it. There was one moment where he stopped the attorney who was deposing me stopped in the middle of his questioning, and he looked real frustrated and he sighed and he went, "Do you have a law degree?" And I went, "No." And then he was like, "Did you go to law school?" No. And he was so frustrated by it because I was calling out his own garbage. Like, I think I objected for myself a couple of times, like I did to you.
You did.
Yeah, I did. I at one point he asked me some question and I went, "What is the relevance of this?" And then my attorney was like, "That's right. Objection, relevance." Like, it was very funny. It was very similar to what happened with you. But yeah, it was funny. All right, guys, I got to run. Omar, thank you so much for being
Oh,
here.
my pleasure, Megan.
I
Anytime you
appreciate
need me,
you.
I'll be here.
All right, wonderful. Well, you take care. Have a wonderful rest of your afternoon, and I'll see you later.
All righty. You guys have a good one.
All right, bye-bye. All right, chat. I don't know what I'm going to do tomorrow. I'm sure I'll be here. I need to talk to Tug and see if we're doing a Tuesday night stream. I might not be able to because I am getting ready to go to Arizona on Wednesday, so I need some time and to get ready for that. And I don't know if I have that at the moment. Anyway, I'll let you know. Check locals, meganfox.locals.com. I do have a couple of super chats to get to real quick. Richard Christofsky, thanks for becoming a member or for 6 months. I saw this first-hand cash for kids happen in backyard in Pennsylvania. That's right. Also, can we get Omar to represent Mike? We're going to talk to Omar about that later. Roy Lonziger, thanks for the 10 to support good journalism. I appreciate it. Yeah, you guys, these streams, I really care about cases like Mikaela Haynes, but these streams never are there's never much revenue to this. It's not a money-making type topic, and I don't know why that is, but it's very difficult. YouTube demonetizes it, and then for whatever reason, the chat is either probably too involved in the story to not like send chats. It's okay. I forgive you. But I would like to do more of this, but it seems like either people are too traumatized by the subject matter and it just doesn't get wide attention, and I wish it did. Ninja Puppy, thanks for the 5, says, "Thank you for exposing this. It's time courts get looked at over these horrific situations." I agree. Fallen Hero 4567 gifted 1 Megan Fox membership. Thank you so much for your generosity. I sure appreciate that. Kitty Meow, thanks for the 5, says, "Late to the party. Clayton on Charlie Kirk." Yeah, I went over that the other night. I don't know if I did the whole thing, but I'll have to talk to Tug and see what we're planning on Tuesday night, if anything. Okay, guys, I gotta go. No outro for me today because I gotta run right now. See ya. Have a great rest of your day.